Yes, welcome to the No State Project. I'm your host, Mark Stevens, author of Government Indicted. Of course, the website, markstevens.net. You're in for 3 hours of anarchy radio right here on the Liberty Radio Network, the LRN.FM, where you can hear the show broadcast 3 hours every Saturday from 1 to 4 if you are in Arizona or you are in the West Coast. It's 4 to 7 on we call it Eastern Standard Time. And, of course, if you're down under, it's Sunday morning down there and 12 to noon. Well, about 9 to noon, depending on where you are. So appreciate everyone tuning in for this April 22nd, 2017 live edition of the No State Project. You want to join me, it's 218-632-9399. 218-632-9399, and Skype is Frank Rizzo 3. Frank Rizzo with the number 3. Oh, and when you call in 218-632-9399, there is a passcode. It should be in the recording, but if not, it is 2020 with the pound sign or the hashtag. 2020 is the pound, and pound sign is the passcode to get in. So if you want to join me on the big show today, you may do that. That's how we do it. So, in fact, why don't we go right to the phones? Because I think someone's actually, wow. We have a new caller who's been actually on hold for a while, but I appreciate the wanting to get onto the show early. But, you know, we have area code 734. You're live on the No State Project. What's your name? Where you calling from?
Hey, Mark. My name is Andrew Kilborn. I'm from Michigan.
And Detroit. Michigan. Are you from near Flint area?
No, Detroit Metro. I'm in Taylor.
You're in Detroit? Oh, okay. I may have to play a clip of that.
This is my first time calling in, my first time learning everything, so I kind of got confused with the radio show and the links and stuff like that. Finally heard the actual radio through the phone rather than through the computer on the PC.
Oh, hey, however you get in the show.
All right, nice.
What can we do for you today?
I don't even know. Well, I've been doing a little bit of research on a lot of stuff, and I am now officially trying to implement all of the things that I have come across, and I screwed up a few months ago in court. I was threatened and intimidated by the prosecutor with contempt of court by the judge for asking questions of my rights.
You're asking questions about your rights?
Yes. I asked, if there was a sworn complaint, what the laws and rules that were governing the hearing of that day. Was there a probable cause determination and such? And the prosecutor eventually told the bailiff to go and tell the judge to motion for discovery off the record in a private room that was off to the back of the court. And he, as soon as the bailiff court officer left, the prosecutor leaned in and said, I don't know what you're trying to do or what you're trying to pull here, but if you go into that courtroom and you try to make the judge think that you know more than him, he's going to take it personal, and you don't want to be held in contempt. All for simply asking questions, because I asked him if the charge was criminal, and he said, well, it's not a felony, it's only a misdemeanor, you don't need the probable cause hearing, and something, and things to that effect. And I said, again, well, is it criminal? And he said, yes. All right, so where's the probable cause determination hearing? And then that's when he told the bailiff to go ahead and motion for discovery from the judge.
Okay, well, would you say that slower? A probable cause termination hearing? What?
A probable cause determination.
Oh, okay. Well, actually, they don't have formal hearings or preliminary hearings, probable cause hearings when it's a misdemeanor.
Okay.
There's supposed to be probable cause, yes.
Otherwise.
Yeah, there's supposed to be probable cause, of course, to make the arrest. However, they don't have a separate probable cause hearing where you have the opportunity to put the police officers or other witnesses on the stand.
I see. Well, I shouldn't say a hearing of the probable cause determination. I should have said a probable cause determination or hearing. That was my fault. Because they do that all on their own. In the state of Michigan, under the Michigan Court Rules of Civil and Criminal Procedure, there's a certain thing in order, MCR 6.101, 102, and 103. And I ended up pleading guilty on the charge because of the threat of intimidation and of all this stuff. And I was hoping that I could figure out how I could go back. I've already filed a motion for a withdrawal of my guilty plea, and I'm waiting on my hearing, which is Tuesday, for that. I've already served the prosecutor of that motion and such. So I'm hoping that there's a way that I can backpedal this and hopefully try to challenge jurisdiction.
And yeah, you don't want to go in there asking questions such as you did. I think it's better to, of course, hit them on the issue of jurisdiction and an essential element of the crime that's not there, which they cannot provide any evidence for, than go in and do. You could still get threatened, absolutely. It doesn't mean they're going to be nice guys and, oh, he's asking reasonable questions. No, they still might. You could have someone like Richard Noble isn't actually the judge you're seeing, is it?
No, this is in Southgate, Michigan. His name is James Kendravis.
Okay. I guess Dick Noble, yeah, he's up there in Michigan. So when you get in there, obviously the judge may just, you probably stand a good chance of them withdrawing that motion, vacating. They're going to still want you to plea. So it seems like a no-brainer that they'll withdraw the plea, but they're still going to expect you to plea. So what do you plan on doing?
When I went in for all this stuff, I tried to file the motion before I went in for the sentencing hearing to file to withdraw the plea, and the court clerk refused to file my motion. So I ended up bringing the dispute up to the judge in front of him, and he denied my motion on the record. And I ended up filing the motion again as soon as I left the courtroom after being sentenced to withdraw the plea, because the judge didn't want to hear what I had to say. He wasn't even really trying to hear it. He just said, all right, well, motion denied. And then I tried to bring up other things from the probation officer that was trying to introduce prejudicial information. So either way, he said, well, that doesn't matter. You've already been sentenced. Have a good day. So I left and refiled the motion with the clerk.
If you've already been sentenced, it's, unless you're going to file something to vacate the sentence based, let's say, on a lack of evidence proving jurisdiction, that there was coercion, there was fraud. If you've already been sentenced, then what's the point of this hearing on Tuesday?
That was the motion to withdraw my guilty plea due to the fact that I was coerced and threatened into the plea.
Okay, so you still have an opportunity to get this thrown out. Okay, I understand.
Correct.
All right. Well.
Yeah, there's a 6-month time frame after sentencing that I have in order to pull the plea back.
Okay.
To try to get it withdrawn.
So what do you plan to do if the judge grants it and throws out the plea and the sentence?
I'm hoping to try to backpedal it back to an arraignment and try to challenge jurisdiction.
What if he just insists? Well, I do have the motion to dismiss template available. You don't have much time to file. I guess you just bring it with you, and when he asks you, how do you intend to plea, since it's not going to be guilty again? Well, it could be. So look, hey, we'll get to that. So look, I have a motion to dismiss. I mean, we've been at this for a little while now, and I don't see any evidence on the record. Do you see any evidence from the prosecution that would prove that just because I'm physically in Michigan, that your Constitution applies, and if there's any jurisdiction over me at all to even have an arraignment or even to require a plea? He's probably going to give you a ration of crap about it because that he just wants a plea. So we'll talk about the unsigned plea of guilty, which they're not going to be too happy to hear in the first place. So we're up against the break. So just hold tight. My name is Mark Stevens. We're talking with Andy in Michigan. If you want to join the show, it's 218-632-9399. 218-632-9399. 2020 and the pound sign is the passcode to get you in. We'll be back in just a moment. Yes, welcome back to the No State Project, live from the Fortified Compound. It is April 22nd, 2017. 3 hours of Anarchy Radio right here on the Liberty Radio Network. Anarchy meaning an absence of rulers. We reject the concept of rulers in a ruling class and reject a double standard used to justify it by those who refuse to think and rationally on the subject and actually question it. That we reject the double standard, that it's wrong look, we all accept that it's wrong to lie, steal, kill, and cheat people. Okay, the double standard is to justify having a government and a ruling class. It's okay to do those things if you call yourself a government. So we reject that. And because we've got someone from Detroit on, it has been a while, we have to play the infamous clip.
And as for my American friend, the CIA thinks it can infiltrate the mountain of Dr. Crud?
You can't scare me, you slant-eyed yellow bastard.
Take him to Detroit.
No! No, not Detroit! No! No, please! Anything but that! No!
That is always funny. So, Andrew, getting back to this, you do realize that even at this late a time after sentencing, the chances, the more I reflect on it, it's going to be tough. It's going to be tough.
Yeah.
But let's go with, because the only other option, if he refuses, then you have no choice. You do have to appeal and bring up the coercion on the appeal. But let's get to where we're working as far as that the judge does strike the plea and the sentencing and starts over, and you're at a position where they don't want to hear the motion at this time. They want only to know if you are going to plead not guilty now. And he may just say, all right, we're going to strike the plea and not even give you an opportunity to plea. He may just say not guilty, we'll enter a not guilty plea for you because you want the guilty plea stricken. So what do you do?
I'm not completely sure. So I'm hoping to find out.
Well, you can object and you can say, I wanted the plea of guilty stricken because I was coerced to do it. It doesn't mean I'm not open to a guilty plea.
Okay. All right.
So that's a way to handle that. And then you can go, I intend, and you can say, first start with, has the prosecution submitted any evidence to prove that just because I'm in Michigan, your Constitution and code apply to me, and that there's jurisdiction at all. If he's going to refuse there on that and just say, screw you, we just want a plea, then you can try and use the unsigned plea of guilty.
I see. Okay, now with my motion to withdraw my plea, I put in there, on the background a statement of facts, of everything that happened with the prosecutor, everything that he threatened me with, after every question, so on and so forth. I'm hoping that once I try to get this backpedaled, that they will see that when I try to appeal the decision and everything else, that, if they grant the motion, then they're going to grant all the background and facts of the motion as well. So, and in turn, I would, take that to the appellate court, which would in turn try to put a blemish on the court and the prosecutor, and hopefully I would try to file charges against the prosecutor for threatening me as a witness against myself, in a sense.
Well, you're not going to get charges. Come on, you're not going to get charges against the prosecutor. It's not going to happen.
Probably not.
Unless he was using a gun or, had some kind of, a bat. He was pulling a Negan. No. The best you can look for is just to have the plea on appeal get thrown out and get it reset for an arraignment.
Okay, and then still just challenge jurisdiction that way.
Yes, it's not just jurisdiction, but you're also showing that the complaint does not set forth the sufficient evidence for an actual charge, because they're assuming that the code applies. So it's not just jurisdiction. Yes, jurisdiction is extremely important. It's part of the charge, but they're also talking about an essential element to the charge, because code violations are only violations because of the code. So they're assuming an element of the charge, and they're supposed to have evidence. So for you and others listening, it's not just a jurisdictional challenge. It's just that the applicability of the code is jurisdiction and an element of the charge. And if anyone says that the code itself is not an element of the charge, you have to first explain how it's not a part of the charge when the charge only exists by virtue of the code. Mala prohibita, baby. And if you have to explain what it is...
I don't follow that, I'm sorry.
Okay, mala prohibita, as opposed to mala in se. Mala in se is a real, actual crime. It's redundant to actually pass a statute saying that a mala in se crime is a crime. Its very nature is harmful. It's an involuntary human relationship or interaction. That's all a crime is. It's an involuntary interaction between two or more people. And murder is one, rape, robbery, fraud. These are real crimes that you don't have to pass a statute making it a crime. It's a crime by nature. So you pass a statute saying it's a felony or a misdemeanor, and you pass a statute that says that it's a class 1 felony or a class 2, and how much punishment is assigned to it. But you don't need a statute that says it's wrong. Mala prohibita is an act that is not inherently wrong or evil. It's what you call a victimless crime. It's only wrong because so a group of criminals said it's wrong. So driver's license, most traffic offenses, tax evasion, willful failure to file, these are only crimes by virtue of the statute. So it's impossible to say that someone committed the crime without including the statute, because it's only a crime because of the statute. Yeah, but they don't have to prove that. So again, objection. Are you allowing the prosecution to assume an essential element of the crime, which is what it comes down to, and every element has to be proven beyond a reasonable doubt.
Okay.
So that's why I'm very. I say that so often because I don't want anyone thinking it's purely a jurisdictional challenge. It is a jurisdictional challenge. It also goes to an essential element of the crime. So good question. I'm glad that I had the opportunity to explain that more. But holy crap, we're up against a break again. Man, these Wednesday shows are so much nicer to do than. All right, hey, just hold tight. We'll finish up in the next segment. Whatever questions and concerns you have, and we'll be back with more callers at 218-632-9399. Don't go away. All right, I'll be right back. Yes, welcome back to the No State Project here on LRN.FM. April 22nd, 2017. 3 hours of anarchy radio. And, of course, anarchy meaning no ruler. Why would anybody actually say that they wanted someone to rule over them without their consent? Oh, that's right. There are a number of reasons. Because most people characterize what anarchy really is. That's all it is, an absence of rulers. Doesn't mean chaos, doesn't mean mayhem. That's why we're not anarchists anyway. We don't use that particular definition of it. But welcome back to the big show. If you want to join me, you may do so on Skype at FrankRizzo3. Don't call, but instant message me first, and then I can get you on a break. Or it's 218-632-9399. 218-632-9399. And the passcode is 2020 with the pound sign. I actually did radio years ago, and there was a guy that insisted on talking like that. And I just didn't understand why the hell somebody would go and speak like that. Welcome to the No State Project right here on LRN.FM. 124. I want to shoot myself in the face, but if just so. Anyway, it's 2020 and the pound sign, or 2020 with the hashtag So I want to get back to the caller, Andy in Michigan. I kind of looked at the chat, and my explanation of mala prohibita and mala in se are still applicable for code violations. However, I'm starting to see, is this a what were you actually charged with? What particular section? What code section or what type of charge is this? Because I don't think I ever got that from you during the call.
Well, it was for an accident. There was an injured party. There was no determination on who was at fault for the accident. I received driving on a suspended license and no insurance. And to be honest, I panicked, a few years ago. And I had warrants, because of unpaid tickets that I couldn't afford and because I had a suspended license. So I took off on foot like an idiot. And I finally, paid a bond to try to get all this stuff squared away. And from my understanding of what I've spoken with other people, if I try to take care of the injured party monetarily to compensate for their damages, then there should be no reason for the state to come after me criminally for these, charges.
Well, there shouldn't be, but some of these charges are mala prohibita, some are mala in se because you left the scene. So you have a mix. You have a mix here of mala prohibita and mala in se.
Okay, so the plea agreement that they gave me with was they were going to drop the failing to stop and identify if I pled to driving on a suspended license. And that was the plea agreement they had made to me after they had threatened me. Because when they threatened me and in the prosecutor motion for discovery, I went ahead and went to the courtroom because he told me to go ahead and wait. And while I was sitting in there, I'm sitting there thinking, like, shoot, they're threatening me with jail time for asking questions. And I'm here by myself. I traveled, here by myself in my property, and it's in their parking lot. And they tow after 11 p.m. My tools for my job are in the vehicle or in my property. So I went ahead and asked the bailiff to go back into the prosecutor's office to try to talk to him and see what else I could do. And so I didn't get held in contempt. So I ended up, making the plea agreement anyway.
Yeah. All right. Well, if you get it tossed out, great. You got more of a jurisdictional challenge here. Yeah, you're gonna have to focus real hard on that, and not so much on. Well, not yeah. Yeah. Well, let's take it one step at a time. Let us know on Tuesday how it goes, but do some role playing and make sure you stick to. If they do allow it to be vacated, that you stick to the prosecution's burden on jurisdiction.
Okay. All right.
All right, and good luck. Let us know how it goes.
All right. Sounds good. Thank you very much for your time and your help. I appreciate it.
Hey, no problem. Thanks. Andy in Michigan. And we've got somebody. This might be the first time that I've done this, and I just want to know that he's rolling his eyes right about now.
And as for my American friend, the CIA thinks it can infiltrate the mountain of Dr. Crud.
You can't scare me, you slant-eyed yellow bastard.
Take him to Detroit.
No! No, not Detroit! No! No, please! Anything but that! No! No!
Anything but that. But welcome back to the show, Tom from Detroit. Tom.
Hey, Mark, how are you?
I'm doing well. I looked at some of the chat, and I kind of figured that Tom's head's either going to explode or he's going to call.
Yeah, I had to because I spoke with Andrew. Several of us did earlier, got the whole story, and I'm just going to ask some questions now. Okay, let's say that he goes in there Tuesday. After now he's admitted in open court to the judge that he did do this, that he did cause those damages, and pled guilty, went through sentencing. Now I'm going to go back and I'm going to say, you know what, I changed my mind. Let's start all over. How could this possibly help him with that admission on the record when he goes to his next, there's going to be a trial, obviously, or something, how is this possibly going to pan out in his advantage since he committed that he did create damage? This is not a prohibitum case. It's both sort of because, but he admitted to it. How can this possibly go well for him? You tell me.
Well, one, he'd have to have a different judge. It should be textbook that he'd have a different judge, and that the jury would never hear. They could never discuss in front of the jury what he said in a plea agreement, ever. That would be grounds for a mistrial. It's also...
But he did it to the judge. He was standing in the courtroom to the judge, told him he had committed this and pled guilty. How can that not be? You're telling me that can't be brought into to a next trial?
Hell no.
Huh. Okay. Well, I mean, the guy, he feels that he wants to do right and somehow pay the people back. That's the other thing. If you're going to try all this stuff and you've got zero money, okay, you're digging yourself a deeper hole. He's got an out right now. It's probation, which I suggested I would never go back on probation. He's in the Wayne County system. He's already was convicted to a year on some other crime and only spent 98 days in there. Even if they give him 6 months, he'll be out 30 days, and it's all done. To go back and do this, they are going to rake him over the coals. If he doesn't see that, I don't know. I'm flabbergasted.
Anyway. It might turn out that way. However, it might turn out that if he gets it in front of a jury, he may be able to mitigate some of the damage. Maybe they'll acquit him on the mala prohibita, and that may be mitigate. A sentence may be mitigated. Because he's. Excuse me. Wow. Because he's trying to make an effort to pay them back. It could absolutely look. Every time we go into these things, it could actually, wind up worse. Especially depending on where you are. If you're in Texas, it could absolutely wind up worse. At least money wise, it could be financially destructive. But here he may, they can't mention what he had said, and it's going to have to be in front of a different judge anyway. So we're up against the break, so let's explore this when we have more time in the next segment. So just hold on a second there, Tom. My name is Mark Stevens, listening to the No State Project here on LRN.FM. Texas equals dead. Oh, gosh, I didn't mean it that way, but we'll be back here on the No State Project in just a moment. Don't go away. Yes, welcome back. This is the No State Project. If you are not able to hear it live, of course, if you missed part of the show, get it posted at markstevens.net. Thanks to Calvin. And I'm real sorry. We'll bring Tom back. I lost all the damn good audio for that video. Well, you got some background noise there, Tom.
No, not me. I'm dead silence here.
That was weird.
Yeah.
Wow. Okay, well, hopefully that's not coming out over the air.
I don't hear anything.
Okay. The guys let me know in the chat if the background is coming out over the air. But I lost all the audio, the good audio that I sync up with the HD video for the show, and I just went with the live stream, which, won't be the case this time, though. It was a really stupid mistake. It was out of like 100 files. The only one I absolutely could not have deleted got deleted. I felt and there was no recovering it. I was son of a. Anyway.
What audio are you talking about? The show? I can't hear the show because I've got it off. I'm listening to you right now on the phone. Are you talking about the show itself live right now?
No, I'm talking about when I did the live Wednesday show, the live stream. And what happened was, because what I do is I have my good camera recording at the same time, and then I have my audio that like I'm recording now, which is a much higher quality than you can get from a camera, and then I edit it together and sync it up, and then I post the video, and so you've got high quality audio and video, but I wasn't able to do that for the last Wednesday's show because I accidentally deleted my WAV file, so
Okay.
And I'm getting really good comments, like it's great material, but what do you do? What do you do? I can always redo it, but let's get back to our discussion here. I think we were saying that every time we go into these things, we run the risk of having the situation be made worse. I mean, you'd be the first one to agree to that.
Exactly. And especially, like I said, at this point right now, with him admitting it, and he knows he did wrong. He even wants to be the bigger man and pay for the damages that he caused. And my suggestion right now, because of his financial situation, that he doesn't have a job, he has zero income. They've offered him probation, which again, I don't like probation. I definitely don't want to sit in a cage, but he could do this in probably 30 days, and it'd be all done. You go on probation for a year. He doesn't even have the money to go in and do the piss test and the drug test and all that. He doesn't have a vehicle that he can drive because he doesn't have a license, and they banned him from driving. I mean, and now he wants to poke the bear and start over? That's just stupid, man. I'm sorry. So, I had to call in because I didn't think that you did finally get the entire story more or less out of him. That it is a mala in se case. He did create damages. This is not a mala prohibitum. It's a little different. And I did want to ask something besides that. I've listened to a show twice now called Rule of Law Radio. I'm sure you probably have heard of it, right?
It's been mentioned, yes.
Okay. And what I did like about it, I mean, obviously there's nothing better than the Socratic method, obviously, okay? But it lacks a little bit of teeth, And what I did listen to and what I found very interesting, and a lot of people are starting to discuss it here in these chats, is going at it with a little bit of an offensive also. I mean, when we're filing motions and we're using the case law and, trying to hold their feet to the fire with their own rules they claim to apply to them, these guys here on this Rule of Law Radio seem to like to file criminal charges against everybody right away. And it seems to be somewhat effective at getting, like for instance, when the clerk doesn't want to take your paperwork. They were talking about filing criminal charges against the clerk. And boy, that sure turns things around real fast.
I don't see how, because the bluff. To me, it's just a bluff because the cops have to take, or a prosecutor has to actually accept the charge, and I don't know. Maybe they are doing that in Texas. No one's been able to report. Hey, I went and had the police take a complaint against a clerk. What we've done is we've threatened to go to the presiding judge, and we've had to go to the presiding judge before, and even and so that's helped. But criminal charges against a clerk for not accepting paperwork, maybe it's happened. I've just not seen any documentation or any kind of proof that's true. That it's great if it does, but show me where a clerk has actually, where a cop or a prosecutor has taken the charges and filed them against the clerk for not taking paperwork.
Yep, that's a great question. That's actually what came to my mind also, because I was in a situation many years ago where some guys took their four-wheel drive truck and basically mowed big trenches into my mom's front lawn, and the cops or the prosecutor wouldn't file charges no matter if we were standing on our heads or not. If they don't want to file the charges, they're not going to file the charges.
Yeah.
So you're right. I'm about that. My intention is to call into that show and ask them some questions. So I'm new to it. It sounds interesting, but yeah, you're right. I'd like to see some evidence of that working as well.
We've had people call from England, and of course you can do it in a limited way in England. And you can see that the rules allow that. Yes, I mean I've even seen there's proof of that. It's even been reported in the paper and whatnot. So there's proof of it, but that's not the way it works here. I agree with you. If the prosecutor or the cop doesn't accept the complaint and have it filed into court, because you and I in the United States, as far as I know, we don't have the ability to file directly a criminal charge. The one that comes to my mind is, not that you and I would ever get away with doing this, but you can bring evidence to a federal judge if an IRS agent is violating, and committing a crime, that they'll issue a warrant for their arrest. That may not even be current law anymore. But just filing a criminal complaint, no. When you press charges, even for sexual assault or something like that, they have to file it for you. They have to actually accept it. And I don't see that happening against the clerk.
Right. Yeah, I'm going to call in one of these upcoming shows, and I'm going to ask some of these questions and I'd like to see what their opinion is of this method, and I'm just looking around and trying to bolster this, because a lot of times, like you just said, we have to file this stuff with the presiding judge. It's like, it's like filing it with the enemy. I mean, they just like Dick Noble, classic example. They just laugh.
Yeah, however, we have had some success with that, because it's really not it doesn't matter as long as the paperwork is in the right format. The clerk has no discretion to not accept it. So we have had in a number of small instances where it was, because it doesn't happen that often with people at work. Yeah, they have stepped in. We were able to get the paperwork filed. But if you can do that, I'm all for it. Let's, I think that would be great. That would just be another tool in the box that we can use in those limited circumstances where the clerks will not accept the paperwork. That would be, find out and report back, because, hey, I'll report that.
Right. Okay.
Well,
you have a good rest of your afternoon, sir.
You too. Hey, I'm hoping to get to do some jamming tonight.
Saturday? Ooh.
Well, a few hours after the show, hopefully a bunch of us here, we haven't gotten together in a while, because I can actually, not note for note, because I'm not that kind of a player, but I can pretty much I can do a pretty good job with the Money solo from Pink Floyd now.
Yeah, good job. One quick thing now that just hit me. Last Friday, I got my house surrounded again, and literally for almost an hour, the cops were banging on my door and windows like I have never heard in my life. I mean, this wasn't just a knock, 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 boom, boom, boom. This was like machine gun fire. I thought, this is it. They're coming through. And they eventually left again. So I'm going to get the what do you call it? Not the police report, but the incident report. I'm going to have Dad file for him, because if I file, then they'll redact stuff. I want to know what exactly is in that incident report and what took place. But
hell yeah. That's wow. Well, yeah, let me know. Hey, we're up against the top of the hour break. I appreciate the call as always. You have a good one.
You have a good day.
Thanks. You too. You're listening to the No State Project here on LRN.FM. We're going into the second of 3 hours of Anarchy Radio right here on LRN.FM. Do not go away. Yeah, that's how you nail a break. Yes, welcome back to the No State Project here on LRN.FM. You want to join me on the big show today, 218-632-9399. The access code is 2020 with the pound sign or the hashtag, 2020 in the hashtag. And Skype, it's Frank Rizzo 3. It's Frank Rizzo 3. And Austin sent a link in the chat. And thought we'd play a little bit. This is Dude Jams, How to Abuse Anything, and it's Drink, Drank, and Panic. I've not heard this before, so I'm just going to play it. Punk is not dead. That's Dude Jams, How to Abuse Everything. And maybe I'll send the link to Calvin, and maybe we can get that linked up in the show notes. But he's been on the show before. Bring him back here for it's April 22nd, 2017. And Jay in Texas, welcome back to the show.
How you doing, Mark?
Oh, gee.
Sorry, I was trying my best Peter Steele impression. Didn't work.
Well, hey, that was pretty good.
Thank you, sir. Well, I've been in this game long enough to be able to make a couple of observations, and one with regard to strategery. And every time that I have submitted the motion to dismiss as the first action, I have always had the burden of proof. Well, they try to, swap the burden of proof onto me.
Yeah.
And I was wondering if, yes, the motion to dismiss, have it ready in the holster, and then, show them the unsigned plea of guilty. Offer, hey, I'll take guilty plea right now if the prosecutor can meet up his burden of proof. And then at that point, when they start to stutter, be like, oh, okay, well, then I have this motion to dismiss right here. Would that be a more, or at least a good countermeasure to that kind of tactic?
It might be, but I just want to explore a little about the actual mechanics of them trying to flip the burden of proof on you. What are they actually saying? You filed a motion to dismiss, and so who is saying what?
The judge. Actually, with my federal case, with a couple of traffic incidents, I filed a motion to dismiss, and then they go to the motion to dismiss, and then they'll say, well, this is your motion to dismiss. You have the burden to prove your points here. And to which point I say, well, the only reason I'm putting a motion to dismiss is because the prosecution has, made some claims here, and they don't have any evidence to put it. So why am I on the hook? Because I'm the one submitting a burden, or submitting a motion to try to get the prosecution to meet their burden of proof. And I'm just saying, without variation, the judge has said in whatever way, different judges, different things, but the ultimate thing is like, oh, it's your burden of proof because it's your motion to dismiss.
Okay, well, you could say, well, excuse me, sir, do you see the missing evidence in the record?
Yes, I've used that too.
If he's going to keep insisting, you can say, well, I'm showing, sir, there's nothing here in the record.
Yep. Or could you point it out on this citation?
Yeah. If you think,
which is,
yeah, you're right. If you think that that the prosecution has met, could you please point out where in the record is this evidence? But sir, it's your burden of proof. Yeah, I'm doing that right now. I'm demonstrating to you by having you point out where in the record do you see the evidence.
Mm-hmm. Yeah, no, I've seen that both ways. I've seen it where they kind of get paused a little bit, and I've seen it where they say, well, it's in the complaint. Like, oh, okay, well, is the complaint, is this prosecutor giving testimony? Especially here in Texas, if they start like naming off facts without anything, you have to object and have them sworn and put on the record and submitted to cross-examination, or just their say-so will go on the record as fact.
Wow, you think they're elevating a prosecutor to the level of a judge?
Oh, sure.
Wow.
Might as well. Well, my second thing, and thank you for listening. This second thing is I was involved in a lawsuit here recently, unfortunately, to recover for some damages. And I had a very weird thing from a judge happen where there's this guy, he's the CEO doing business as guy named Gallegos, and he's the guy that damaged me, and unfortunately I had to use the system to try to get some of that money back. And the judge asked me the guy's name is Willie Gallegos. Well, the judge asked me two times. He says, do you know a C Gallegos? And I said, no, Judge, I know a Willie Gallegos. He's the CEO doing business as Superior Home Improvement and Tile, which the acronym is SHIT, which is hilarious. So anyway, he asked the second, and then I'm asking for about $10K just to recover, because he installed a roof, faulty install. I had to go up there and repair a bunch of stuff on my own, and I'm asking for about 10K, and the other 2K is my time and my money and damages, and you know. But anyway, he at that point when he says Willie Gallegos, C Gallegos, he makes that, and then he proceeds to drop me down to 5K, and I'm thinking, what the heck is going on here? It's like he's not the judge is basically making arguments on the behalf of the defendant who's not even there.
Was he making an argument, or is he just dropping what he believes the damages should be?
He dropped the damages, but then his argument for that to the why was he did some work. He did do some work. Now, of course, it's basically saying like, you got a roof, jerky. Be happy that there is a roof.
Jerky.
Like what? Like I had to replace my roof because of some hail damage. Well, what good is a faulty roof if I got to go up there and fix it myself? Well, the interesting part is I get home and I talk to my girlfriend and tell her what happens, and she says, "C Gallegos, Well, apparently there's a senator or a state assemblyman by the same name, C Gallegos." And I'm wondering if this judge knows a cousin or a brother or a relative of this guy, and gave him a break on the damages.
Yeah, you would probably need some like a private investigator to help make find out if there's a connection if you can't find anything online.
Right. Well, I mean, I've looked at it. Yeah, there's a C Gallegos, but I can't. There's about 1 million Gallegoses down here, so. It would just be interesting because the moment he said C Gallegos, Willie Gallegos, he paused a minute, and then all of a sudden he became all tears and heartstrings for the no-show defendant. But I got the default judgment. You use a crap system, you get a crap outcome. So
yeah, well, if it's worth it to spend on if you can't find anything online about it and do your own investigation, you might have to hire a private eye, and that's going to cost you some money. So you have to see if that's worth it. I do have to point out, because I noticed in the chat, strategery is not properly attributed to George W. Bush. That was Will Ferrell on Saturday Night Live was the one that used the word strategery. I haven't heard that in a while, and I got a good laugh at it. No. Okay.
Was he doing a Bush impression?
Yeah, they were doing the debates in 2000, and they said they wanted one word to describe what your presidency would be like, and Will Ferrell goes, strategery. We're up against the break, so just hold tight, my friend. We'll be back here on the No Stay Project, also taking your calls at 218-632-9399, 218-632-9399. Don't go away. Yes, welcome back to the No Stay Project. I'm your host, Marc Stevens. The website is markstevens.net. If you want to join me on the big show, it's 218-632-9399, 218-632-9399. And as a bass player, you'd appreciate the bumper that you just missed. It was Cliff Burton.
Awesome.
Yeah, and I found, so I got to play this. So just hold up 1 second.
Please do.
Almost out of time.
Yeah, I got the clip.
So I will instead ask each candidate to sum up in a single word the best argument for his candidacy. Governor Bush?
Strategery.
Oh man, that's always funny. Gee.
Like, it would be more funny if it weren't true, or even worse now.
One of the comments though on that YouTube, on that video, it was, they were lamenting that of a time when it wasn't normal. The good old days when it was considered weird for politicians to be stupid. Damn. The thing is, it was, the brilliant part of it is it was something that Bush would have said.
Yeah. I always laugh when I think of the mission accomplished photo stunt he did. Iraq's in flames, soldiers are dying, and he's on the aircraft carrier just going like, yeah, we did it. Yeah.
Yeah. So much you could
Meanwhile,
read.
10 years later,
14.
14 now. Oh, yeah, sure enough.
Yeah, it's been, maybe even more. I forget exactly what year it was, but yeah, that's
Invasion was 2003.
three.
I think.
That's where I said 14, but okay. Yeah, it was. Yeah, I'm sure it was two. Yeah, there's so many things you can, too many OBGYNs can't practice what they love. There's just so many. There's no saying.
Whole websites dedicated to Bushisms.
Yeah, well, that's what came up too when I got that video, that the clip we just played. There's whole videos there. So if we post a link, you'll see that the best of the Bushisms.
Shame, fool me once, shame on you. Fool me twice, can't get fooled again.
Fool me once, you can't get fooled. Yeah. Oh man, funny, good stuff. But I do want to get back to this issue because I know I did a video on this, and it's always worth getting into. I did a whole video a few weeks ago or a month or so ago about flipping the burden of proof, and it's extremely common. So when you brought that up, what's interesting is that it seems to be happening a lot to you, but it's not necessarily something that happens so often to a lot of other people.
Mm-hmm.
Usually when I get that, it's not in court.
Well, like I said, it's just an observation that, at least in my travels and experiences, have come across just every time without derivation. Derivation, is that the right? Anyway, without change. It doesn't. Yeah. It's every time. And I was just thinking that perhaps the because they don't like the motion to dismiss anyway. But if you're using the element of surprise, use a little Sun Tzu on them and. Just be like, oh, that's interesting. No burden of proof. Okay, well, here's my motion to dismiss. Could we please discuss this now? And I know for a fact that the prosecutor would then turn extremely pale and probably ask for a recess.
They typically do. Whenever the judge just looks at the prosecutor, do you have a response to the motion? They'll typically go pale, start stuttering. I need more time. I need 30 days. I need 60 days, which is, a very common thing. But I guess, one of the things I've mentioned too with this is if it's in court is to say, objection, who has the burden of proof here? To prove, yeah. Oh, the prosecution. My motion's just saying they haven't met their burden of proof yet. Well, you have to prove that. Well, I have the complaint. There's nothing on here. Do you see something on here? It's pretty easy. So, and this is where, so if you look at the instructions, I know you and I go back a long time. In the instructions, and when I mention when we're going to file the motion to dismiss, I let people know that it is important if you can call the prosecutor ahead of time and ask them the questions so that you can then take their statements, which I always like going back to San Diego with Delilah. Samson and Delilah. And the prosecutor, I don't remember his name, but it is in Government Indicted, available at markstevens.net. The prosecutor told me I'm not going to go there. And so we were able to use that against him at every proceeding and in all the paperwork. So if the judge actually says, well, it's your burden to prove this, yeah, well, it's laid out in the motion to dismiss, you jackass. You're going to take a couple moments and read it? Right. Is it your position that in my motion, I have not met my burden? You know what it is, Jay? It is something that is such a stupid thing to do. It is so dishonest that it jars you a bit. Because like, I laid everything out in the motion to dismiss. Didn't you read it? Are you telling me I did not meet my burden of proof in the motion to dismiss? Yes or no? I mean, that's really what it comes down to, right?
I agree, and I've used that, but then it's always turtles all the way down. They're not going to and at that point, like I'd start to leverage the judge a bit. Like, I'm sorry, are you making arguments on behalf of the prosecution?
He might, and so you may have to object and say objection outside the pleadings, because chances are he's going to go. If you're in a typical situation, traffic, taxes, or they are going to go outside the pleadings.
Yep.
So that's another one you definitely want to hit them with. They love to do that, especially in tax cases. And the thing is, Jay, I'm going to do a whole video on this because I now have more documented proof, what I believe is very strong circumstantial evidence, that an appellate panel, the Ninth Circuit, did not read the brief at all. How do you actually accuse a sitting federal judge and a U.S. attorney of being liars, and it is not even mentioned in the decision?
Oh, well, that's what happened to me with the TSA. They didn't read any of it.
Oh, no, absolutely not. But this is, just like what they did with Good Will Hunting, they intentionally stuck a very graphic gay sex scene right in the middle of the script just to see which producers were reading it and wanted to greenlight the script on the merit of the script instead of just on their names. And so I intentionally put those things in there and called a federal judge, Stanley Boone, a liar. Not a word about it in the decision, which was only like 2 sentences long. Well, I'm talking over the great Cliff Burton now anyway, which is a sacrilege, as you and I would agree.
Agreed.
But we're up against the break again. We'll be back in just a few moments here on the No State Project. Don't go away. You want to join me? It's 218-632-9399, and the passcode is 2020 and the pound sign. So don't go away. We'll be right back. All right, here we go. Well, we're back live. Back live here on the No State Project, LRN.FM, the Liberty Radio Network. We're halfway through 3 hours of Anarchy Radio already. Who could believe it goes so fast? But hey, when the material is that damn engaging, you got to expect it. And I'll get it out there now. I will be live this Wednesday, and I'm going to take steps so that we can continue with the HD video and audio, unlike what happened last Wednesday. But good material. Always worth repeating. Treat everything as a cross-examination. We're using the Socratic method for a reason. We're challenging other people's claims and trying to bring out the contradictions in their claims, which is why something on the chat earlier about, if you want, you should learn the rules of court. You should learn court procedure. You should know how things go. Absolutely. Because knowing their due process rules, knowing what's supposedly required is necessary to then use the Socratic method to bring out contradictions, such as they are men and women forcing us to pay them, i.e., criminal, and they're claiming to be protecting life, liberty, and property, being obligated to protect you. So we ask questions to bring out that obvious contradiction, and knowing their court procedure is necessary. It's all online. This is not 1998 anymore, or even 2004. All that stuff is online. Hell, most courts, if not all unless you're in little tiny towns, have the dockets online. As we've seen, because we have markstevens.net, the success stories, that's a lot of times where we get the documentation to show that something was dismissed. So there's no excuse. Learn the court procedure as well as learning your logical fallacies and your objections. So if you want to join me, it's 218-632-9399. The passcode is 2020 and the pound sign. We've got somebody, looks like from upstate New York. But we got area code 518. You're live on the No State Project. What's your name? Where are you calling from?
Hi, it's Julia from upstate New York.
Julia from New York. What can we do for you today?
I just have some questions for you. I emailed you earlier. I don't know if you remember what I was asking you about.
I get a lot of emails, Julia, so you're going to have to bring me up to speed. And plus, we're on the air, and even if I knew exactly what you were talking about, it's probably better that we let everyone else know.
Okay, so the email that I sent you, I was just asking if a traffic ticket is an adhesion contract, and you said no. But my point of asking that was, when you look at a traffic ticket, everything is boxed in, at least in New York State. They box everything in, and I've seen that in a contract, when something is boxed in, it is not part of the contract. I was wondering what your thoughts on that were, if you know anything about that.
No, I don't know if there's validity to that. I do know that when you're writing something, and let's say I'm quoting a Supreme Court case, or I'm quoting something somebody said, and I'm going to add something to clarify the quote. So in the quote, if I'm adding something that wasn't originally there, I will put brackets, the straight brackets. So that will indicate, as far as English usage, that is not part of the original quote or the original text. As far as something being boxed out, that it's not part of a contract, I don't know. I think here it's not even relevant because they are using force. They're not using, there's nothing, the factual elements necessary to support a conclusion that there's a contract are all missing, basically, when you're talking about a traffic ticket. They're not making you, I'm sorry?
It's an offer. It's an offer to appear in court.
No, it is an order to appear in court. Because if you do not show, they will issue a warrant for your arrest. It is not an offer. They are. If you want to use the word offer, they're saying we're going to offer you a choice. You do as we say, or we will kill you. That's, it's one of those things. I'm going to make him an offer he can't refuse. It's not an offer in the contract sense. It's an offer in the criminal sense.
Yeah, I see your point. Okay, so that you're probably thinking that won't have any weight in getting this dismissed. But also, I wanted to ask you, say if you were in this situation, I'm trying to help my friend get out of a ticket and get it dismissed. He got a violation of the New York State Traffic Code. It's 1225D, which is the use of a portable electronic device while operating a motor vehicle.
Okay.
And what you would do if you were in that position. And that it's going to be tried in a town court.
Well, what I would do, wow, what the hell's going on there? Got a lot of background noise there. It's all right. Let me mute you up while I answer the question. So what I would do in that situation it's the same as I always do. I start off with the motion to dismiss and the discovery request. Now, in New York, they don't have pretrial discovery, but they do have to permit and provide Brady material, which is any evidence or information that shows that you're innocent, and any information that would impugn or goes to impeaching the witnesses that they plan on calling against you, because as far as the motion to dismiss, we're challenging the sufficiency of the complaint. Is there sufficient evidence to show that there's jurisdiction? Is there sufficient evidence to set forth a valid claim against them? I don't believe that there is. I believe that the evidence shows that they are assuming that, so we put that in the motion to dismiss. There's insufficient evidence to set forth a valid claim. There's insufficient evidence to show that there's any standing to complain, and that the prosecution couldn't possibly, it's just not in the record now. And we don't think it's possible that they could. So that's how I started.
So one thing that confused me about the ticket is the police officer is listed as the complainant, but the actual case is the people of the state of New York versus my friend Tony.
Right, that's standard.
So is the complainant, is that the plaintiff, or
yeah, it's the same
would he
thing.
just be a witness?
Yeah,
but I don't understand how the prosecutor would be a prosecutor. Like a district attorney is only supposed to prosecute criminal charges, but if if the police officer is the complainant, I don't see, like, how any crime was... I mean, I'm just confused, like, how they kind of blend the two together, you know, like...
Well, what they do is they claim that even though the police officer signs as the complainant, he's not acting for himself. He's acting on behalf of this fictional entity called the state of New York, or the people of the state of New York.
Okay.
So that's all that means. So they try to claim then when they get into court that the cop is only a witness. That's not true. He signed the ticket, and like in Arizona, it says complainant, and it'll say officer, jackass. And they don't want the police officer to have to go under any scrutiny, whether it's on cross-examination or not, and answer questions regarding the complaint that he wrote. And I think that that's bogus, and it's irrational to hold otherwise. He wrote the ticket. He's saying that you did this, but he still wrote the ticket. And so he is subject then to cross-examination and challenge on that. So, but it's not a mystery as to why they do that. He's acting allegedly as an agent for a fictional entity, or so. We're up against the break, so just hold tight. We'll finish in the next segment or so. My name is Mark Stevens. You're listening to the No State Project right here on LRN.FM, the Liberty Radio Network. We'll be back with your calls and more in just a moment. Don't go away. Yes, welcome back. April 22nd, 2014. Here on the No State Project. Remember, markstevens.net. If you are being attacked by a bureaucrat, you want to learn how to defend yourself effectively against these professional criminals, go to markstevens.net. You can also get a copy of Government Indicted, which has a full model for how we've been so successful and been successful since on 3 continents. Again, that's markstevens.net. And I don't think I'm going to give the caller number out at this point. Julia dropped off, unfortunately, but I think we cover. Hopefully that was the only question. So if there's more, that she can always get back on the line. But we have, I think it's Max. Area code 780. Is this Max?
Hello.
Yeah, Matt. Is this Max?
Yeah, how you doing?
I'm doing well. Where are you calling from?
Saskatoon, my friend.
Saskatoon, eh? Well, welcome back to the show.
Thank you.
Your audio's a little low, but yeah, just...
all the folks on the NSP chats, you guys have definitely led me, taught me a lot, and do I have a lot more to go. I wanted to go about the situation that I'm up against right now. I just went for what's called a case management hearing. They told me that they are not able to provide a recording or a transcript for the hearing I just went through. And I'm not sure what exactly would have happened. They're saying the reason why they're not able to is because everything that happens there is off the record and can't be used in any future proceeding. So from what I gather, from what I understand, there's no such thing as off the record. In my opinion, I don't know. It happened, and the judge entered a plea at that point. So if the judge entered a plea, wouldn't that also not be used in future proceedings?
Well, it doesn't necessarily have to be used in future proceedings. I can see why they would say that conference management or case management hearings are not, because you may, as a defendant, may be, like what happened with Andy in Michigan, be making statements that a jury has no business hearing. So I could see that. I mean, I understand why they would do it. There's some reasoning behind that. But because basically case management is like a pretrial conference like they have in the United States. So you may be discussing a plea and eventually not take it, and it shouldn't be a transcript. I think there should still be a record. It just shouldn't be something that is made available to a jury. But there should still be a record. I mean, you have the opportunity. What if the prosecution made a statement that proves misconduct? Right?
Exactly my issue. There was a ton of issues with what was said there, and it's almost like they knew it. And they made sure that there was nobody else in the room at the time, so there was nobody witnessing it. I did have one of my own witnesses, and he was too scared to go to the courthouse, but I won't go there.
Wow.
It was a matter of what is going on here then. If you're not recording anything, or if you're not able to allow me to give anything, I'm just kind of looking for a way to counter that, maybe by, well, whatever. How do I communicate it to them best, right?
Well, I would imagine if you or someone else is going to go into a case management, that if you told them that you were recording, that they would probably tell you can't do that. So I don't know if it may be worth asking at least. Of course, they'd want to probably frisk you before you, knowing that you may want to record that. Maybe have somebody else record it if you get somebody who's going to actually go into court with you. Or maybe it's just a matter of...
It is recorded already, and it is already transcribed by one of our helpful people on the chat.
Oh.
And, it's a beautiful piece of work. I believe I did send it to you, but I wasn't as effective as I could have been. But I'm still learning, and I think I realized my mistakes, and it looks like I might be in a good situation for the next hearing, but unfortunately it's a trial, so now I have to try and get it back to arraignment and point those errors out and hopefully not trigger them off or show them that I recorded it.
Well, what we should always do, this goes back to Adventures in Legal Land 101. We're going as basic as you can get. How many times have I said, and maybe I just haven't said it as much recently, take notes. When you're in there, you should be taking notes.
I did.
You did. All right. Well,
you can't write everything they say down when they go on a diatribe, though.
No, but at least if someone says, "How do you have such an accurate transcription?" I said, "Look, I was taking notes as we were doing this. I wrote down what you were saying." So
yeah, as long as I point that out at that time, then.
Yeah, if they say something like that, I mean, I've done it before. Somebody else recorded, and I, was able to get, or you don't have to have a direct quote. You could just say they said this is what they said, and I'm as close to my recollection and from my notes. Yeah, but you should have your notes. You have to keep track, especially if you're going to trial, you have to keep track of what the witness is being asked and what they're answering. That's how, you need to have that for cross-examination if you are going to be able to do a cross-examination that's more than just a few questions. So it's going to go back to what was said on direct. So you need to take notes. Anybody who's familiar with me, as I've done the work outside of where I've met them in court or whatnot, knows I bring my notebook with me. I have these books going back to 1997. I have every single one of these books, and I take lots of notes, like Mike in Scottsdale. Great guy. Haven't heard from him in a while, but Dan Gould, he was up there and knows Mike. I had my notebook, and I take lots and lots of notes. We all should do that, make a point of doing that. If you weren't familiar with that, make sure that it's something that you do. We don't just go in with the script. Bring the script with you and your motion, absolutely, sure. But have a notepad so that you can take notes. I have like 10 pages of notes from when I was up in Alaska helping James. So, let me we're running out of time, so we'll have to cover a lot of this in the next segment. But I want to go through because I get a lot of stuff and I can't read and go through everything. So I apologize for that. But we should be discussing it on the show anyway. So walk me through what happened at this case management.
Well, I started to get some clarifications. He's refusing to clarify pretty much everything. Made no attempt to listen to anything I was saying. It was almost as if every time I wanted to say something, he would just start talking.
So
obviously,
did you ask him, could you please allow me to speak and not interrupt?
I didn't get there, but I did say something to the effect of, do I have the right to responsive answers to my clarifications here today? Relevant clarifications.
Okay.
Did get that one out, whether he heard it or not, or pretended he didn't hear it. That's kind of half the battle.
No,
I didn't stay on point enough, for sure.
Okay. Well, did you have a motion to dismiss for prosecutorial misconduct or abuse of process? Did you have one of those filed?
Previously, I did, and
Okay.
I filed a better one when I left there.
When you left there? Well, you might be able to get another case management scheduled.
Yeah, keep in mind this is stemming from August. I'm really getting tired of showing up endlessly.
Do they have a speedy trial equivalent in Canada?
Yeah, it's a case law. Askov is one of them.
Seems like you've run that clock. Well, we'll explore that.
We have someone else here in the group that 568 days, and they still took them to trial.
Damn. Well, okay, we're up against the top of the hour break. We're going into the third hour of Anarchy Radio. So you just hold tight, and we'll get into this in the next segment. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM. We'll be back in just a moment. Okay, just hold tight. You know the drill. We got about 4 or 5 minutes, all right? Yes, welcome back to the No State Project. We are in the third hour of Anarchy Radio. That's right, 3 hours of Anarchy Radio here on LRN.FM, the Liberty Radio Network, 1 to 4 Pacific Time every Saturday. Well, most Saturdays. We'll be live this Wednesday, and so if we're not able to get to your call today, holy crap. We're going to do our best to get to everyone today. But if we can't get to you today, we can definitely call into the Wednesday broadcast. And yeah, we've been known to go over an hour there, but we have no commercials to interrupt the broadcast. Although watching the stream, you may see some commercials if you don't have ad block, so get that. But the conversation doesn't get interrupted like it does here on the Saturday broadcast. But 4+ hours of Anarchy Radio here. And Dissent, always welcome. So we're talking with Max up in Saskatoon, and probably get some video posted of these segments. I think this is very important stuff, and so we want to have that. So welcome back to the show, Max. And so I'm glad that you did Skype me this. The points here. So best way to. All right. Why would I want another case management if none of it could be used in the future? What use is it? Kind of gets me thinking that somebody has not been listening to the show, especially when we have people on from England or Australia. So you can get, it's like a pretrial conference here in the United States, Max. You can get it thrown out at the pretrial, at the case management. In fact, Helen in England, when she got her tickets dismissed and got costs awarded against the prosecution, it was out of case management. It was because of the case management. Maybe the case management is not as effective a tool in Canada as it is in England or Australia, but you can get it thrown out if you're holding the prosecution to the burden of proof well, and the judge isn't a complete douchebag, right?
Mm-hmm.
I know that's kind of a big one. Well, what if the judge doesn't allow it? What if he just talks over me? Well, you're going to have to file a motion to change the judge because he's a bully. And put in there that he's so in favor of the prosecution. I'm sorry?
He disqualified himself, so.
So you have a different judge now?
Well, they put it for 3 months ahead now. They want it to a trial. One judge enters a plea for the prosecution's benefit, and they set a trial date for 3 months later.
Well, okay, so you have time to prep. So you already have a different judge. So you can put in a motion to vacate the trial date and have a case management, or get the motion to dismiss for misconduct, prosecutorial misconduct and abuse of process. You can get that scheduled for a hearing, let's say, in just a few weeks. So this way you can bring all your issues in.
What's the way to do that if they're refusing to get a hearing for it?
They have already refused to calendar your motion for a hearing?
Well, they won't respond to it, and I can't get anybody in the office to respond to me. And
well, have you got in touch with the clerk to get it scheduled for a hearing?
I'll keep trying.
Okay.
They don't do it.
All right, well, let's get back to the actual case management, what happened. Were you able to get any questions in to the prosecution for the evidence to meet their burden of proof and their failure to provide the exculpatory evidence?
No, it was pretty much run right over me. There was no talking allowed, literally. I couldn't object enough, but there was 4 or 5 good objections in there. I got to look at that. That was already back March 9th.
Well, it seems from just what you told me that there's enough to get another case management hearing because you didn't have one.
Exactly. Since when did the case management hearing turn to an arraignment?
Well, you're supposed to have the arraignment before a case management. They run over you and they enter the plea for you, and then they set it for a case management. Case management's a pretrial, part of the pretrial procedure.
Well, from what I'm gathering, a case management is when you want to make a challenge to something, and it's almost like I showed up to a case management hearing with no challenge of anything because I'm not trying to challenge. I'm trying to find out if the prosecution has any evidence.
Well, you are challenging them. You're saying it should be dismissed because the prosecution does not have evidence.
Yeah, well, I don't know. Then how do they schedule case management hearing before a plea?
That is kind of odd. That is odd. Sounds like it's something that doesn't happen all the time because it hasn't been. I don't remember that ever being reported to me. But hey, it could. I would still put it, if you can't get them, I would work for the two things. Get a case management because you didn't have one. The judge was not allowing any discussion on the actual issues that you've raised. And you get your motion to dismiss for prosecutorial misconduct to get that calendared for a hearing. I don't see anything else, off the top of my head that I would do in that situation. I mean, you're not getting any results as far as your discovery material. You're not getting it. The prosecution's just not responding. So, other than getting a hearing, I don't see. The only other thing you could do is file a petition for a writ into the appellate court to try to stop the trial. But, I don't know how well that would work out in Canada. I know here at the state level we've done pretty good at stopping trials that way, but federally, no. We've had zero success doing that federally. Never got appellate jurisdiction on a writ federally in 20 years. So, when they say they do not favor such jurisdiction, they're not kidding. If you're not a prosecutor, they're not going to accept it. But anyway, this is just a provincial prosecution, right? This isn't a federal prosecution.
One provincial, one federal.
Oh, well.
Both federal criminal, though.
So do you have proceedings in a provincial court and a federal court?
That's what I'm trying to figure out, too, is they're trying to mix jurisdictions here. It's the provincial court of the province, and it's a federal allegation. So there's two prosecutors.
There's two.
You spoke to one, remember?
Well, wow. Okay. Well, I know what they have here in the United States is concurrent jurisdiction. So you can actually do RICO, let's say a private RICO action. You can do it in the state court or you can do it in the federal court. So there's concurrent jurisdiction. So maybe they have the same kind of thing here, and it's just easier to prosecute you in the one court. So that's my bet on why they're doing that. So when you had your case management, 2 prosecutors were there?
You bet.
Wow. So, and the judge...
Hours, and it lasted about 20 minutes, and all I could do was object, and the guy just ended up walking off the bench. I'm like, get the hell back here. I'm not done yet.
Well, dismiss the charges, and we can all go. Yeah, we'll dismiss the charges, and I don't care how fast you run off the bench. Who gives, So it was 2-1. And the judge still felt the need to shut you up and talk over you and not address your points.
Bang on.
Wow. Well, I
was still pretty green. I'm still learning.
All right. Well, it wasn't that long ago. It was last month.
Yeah, I know what mistakes I've made, what I could have articulated better now, I think.
Okay, well...
how does a person kind of overcome the whole feeling of intimidation, right? It's, I don't know, I wasn't completely shaken in my boots, but that does play in for sure.
Well, absolutely. I would suggest, like I said, try to get this thing scheduled for a hearing. If you can't do that, if the clerks will not allow that, and you don't have an order, you probably couldn't get an order to show cause petition signed either because the judge isn't signing it. They're not. But then again, there's a new judge, so we don't know. The only other option you have is to file a petition for writ to stop the trial on the grounds that they're proceeding absent evidence and jurisdiction. My name is Mark Stevens. We'll be back here on the No State Project in just a moment. Don't go away. Welcome back to the No State Project. I'm your host, Mark Stevens. It is April 22nd, 2017. Glad to be with you here in the fortified compound in Mesa, Arizona, where it is absolutely beautiful. And if you want to join the big show, it's 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign or the hashtag 2020. And the hashtag. Skype is Frank Rizzo 3. Frank Rizzo with the number 3. Don't call during a live segment like now, but instant message me, and I will get you joined. I will join you during a break. He's been on the show before. Like we say, criticism of the show is always welcome. So welcome back. Let's say James and Gilbert.
Oh, dang, I was hoping to hear my intro song, speaking of the Floyd.
Oh!
Not Echoes, the one that starts the album.
I think actually that is, no, I don't play Echoes. It's definitely not Echoes. I'm playing something.
You do play Echoes during a commercial break or intro.
Well, it's a bumper.
You certainly are playing it.
Yes,
it's live from Pompeii version, if I'm correct, which is even better than the album.
Oh, yes, you're absolutely right. But what I'm playing is from "Obscure by Clouds."
No, that's from Live from Pompeii. That's Echoes.
No.
Anyway,
the one I usually play for you.
Oh, right. Yeah, an album I hardly ever listen to, although it's listenable.
Well, this was a live cut.
70s by far.
Yeah, this was a live cut.
Anyway, for the benefit of the audience, one of these days it's an instrumental with a very Mephistopheles sounding line in it that I should like you to play in dishonor of somebody that I'm not calling to be a critic. I'm calling to just ask you some legal advice, seeing that I guess you are a lawyer.
I've said many times I'm not a lawyer, and I've never been a lawyer.
Why do you talk about having been in the courtroom? It sounds like you're talking like you've been in the courtroom.
Well, I've been
you
in
don't call yourself a lawyer?
Well, I've been in the courtroom, yes, many times, and I've helped people defend themselves. I've actually defended people in court when I was permitted to do so, but I've always maintained that I'm not a lawyer.
Okay, and hence I didn't mean it disparagingly when I called you counselor in honor of the Godfather. That's what they call their lawyer.
Sure.
And you being Italian and all that, just playing on that.
Well, I'm Sicilian,
having
actually.
A little fun.
Yeah.
Oh, is that different than being Italian? I don't know. I'm not wise to that kind of stuff.
Oh yeah, I make it's more of an inside joke with me, but it's with some people it's kind of like saying that a someone who's Puerto Rican is Mexican.
I get you. I get it entirely. Just having a little fun. Again,
yeah.
One of these days, I'd like to cut you into little pieces. Somebody keeps on a nationally televised or nationally broadcasted show keeps on accusing me wanting to murder his family, and I've had enough of it. But I know that the cops haven't done anything about it because they know the guy is borderline, literally.
But Jim,
because there's nothing I've ever said that one can infer by that. So I'm asking for some legal advice to go about getting a redress of grievances with somebody that I'm not going to mention, and I'm not going to lose their show. Because I'd rather ask you about this at a bar that you're playing at tonight if that's what you mean you're going to be doing, unless you're a garage band. Are you a garage band or you play live?
It's more if we get together in somebody's house and play, but there is a place...
Right on, a garage band.
But there is a place that we're going to try that's an open mic night that is by the airport. In Mesa, the Falcon Field. So we're gonna try checking it. We're gonna check that out on Tuesday night, this coming. So that may they had the instruments, and so it's just a matter we can.
Playing after 10, I certainly wouldn't be there in person. You don't have to worry. I'm not a gun-toting Republican, and only fired a gun twice in my life. And that's another. There's many things that I've been slandered by, and I've grown tired of it because I never get to respond, and then I get made fun of for wanting to respond to slander and defamation. And it's grotesque, and it's highly bothersome to me to be called a racist and bigot and want to move to the Middle East and murder people and threaten people with guns and all that kind of stuff. That you know these people, and they've said this often of me, and I've grown tired of it. So I don't know how to file a legal case. Do I have to go to New Hampshire? Can I file it here? Can I do it online? How does one go about finding counsel and suing a radio network for gross slander and defamation of character and literally malicious by these people that that it's time for them to answer for it, because they're not good people. They're terrible human beings, terrible excuses for libertarianism, and that's an aside. But it's criminal. I know that if somebody accuses you of wanting to murder people on the airwaves and the cops aren't going to do anything about it, it's because the cops know that that's not true, literally. But why is it not criminal to accuse somebody? I don't know. Is it criminal to accuse somebody in the public airways of wanting to commit murder, or is it at a civil suit?
I guess I'd have to look at the context in which it's being used. I mean, was it satire? I mean, was it
No, it's not satire at all. The guy's dead serious. You can go on a Facebook page and see, oh my God, be safe. Oh my God, the guy's a lunatic. Really? There's nothing on that page that he cites where I ever say that I want to murder 3 people. I do make fun of his wife because anybody who sleeps with him, by definition, is an ugly dog. By definition.
Well, all right. Well, let's just stick to
that's all I'm going to say.
Libel and slander is not something that I know too much about, and so I'm not in a position to really make a good suggestion on how you would go about doing something like that.
Well, do I need to file papers literally in physical in New Hampshire court, or can I do it in Arizona? Or can I do it online? I've never sued anybody. I'm not that kind of guy. I normally like to handle it non-state and with non-state actors, as in man-to-man. But this person isn't a good person. And by the way, he calls himself a minister. That's criminal. That should be criminal. Well, that should get him put behind bars. But that's just something that the state of New Hampshire hasn't pursued, unfortunately. for not paying taxes and claiming yourself as being a minister of love and peace and liberty. Not. I can prove that to a jury for sure that they're none of those things. I know that, and I don't need a counselor. I can use my own big mouth. But again, I don't know how to pursue these matters, and I thought you actually were a member of the bar, had gone to law school, knew these kinds of things, because I know nothing of them.
No, I know a lot about legal procedure and what to do, but slander and libel is not an area that I'm very familiar with, and the best I don't know, you'd have to look in. There may be something where you could file in federal court because it's a diversity of citizenship, but I don't know for sure. You may have to file something like that in a New Hampshire court.
It'd be a federal court issue?
It may be because
we're
off air. I'm sorry. It may be because it's a diversity of citizenship.
Nationally broadcast.
It may be because it's something called a diversity of citizenship. So if someone is in Kentucky and somebody else is in Florida, because of that, and the state court wouldn't have jurisdiction, then it could be considered a federal matter because there's a diversity of citizenship. But I don't know for sure because it's not my area.
And you have no idea as to whether or not a person can be arrested for accusing someone of wanting to commit triple homicide, when, of course, that's as profoundly sickening and untrue as anything I could ever imagine making up in my own head.
It's
not criminal to call the cops and accuse somebody of wanting to murder people.
Well, it's criminal to call the police on something and make a false report. If they report to the police, if they report to the police, Mr. X is trying to do X, Y, Z to me, and it's false, that's a felony.
All right, good. Then that's all I want to know. I think I will call the police department in that local town and see that this already felon goes back to where he belongs. And we wouldn't be having this conversation, I know, if you'd watched somebody you know or love murdered and then got out only after 8 years in prison, let alone he helped the murderer get away. Who, luckily for the person's family that was murdered, the stupid criminal that was his partner in crime turned himself into the DMT, because right now he could be sailing the Atlantic with his kid and wife. Free man, 30 years hence.
I actually
done a second behind bars.
I don't know. I'm not familiar with what you're talking about, and so I don't know.
Okay, forgive me. I don't know. I thought you might be actually friends with these people. I wish you well if you were. I literally would pray for you, because they're not good people. But one of them, yes, it was found guilty of being accessory to murder and obstruction of justice in a murder investigation. I could never imagine ever lying to cops, let alone giving the murderer a lift to the airport so he could escape. That's just beyond the pale. And he only did 8 years. And he's the victim.
All I knew was that there was prison time. I did not know what it was for, and it's not. I don't know. It's a lot of this drama.
I could only tell you that I only know that from having read a hater Facebook page that I heard on their show mentioned Stop Free Teen. I don't know for sure if that's the fact what he did, but my understanding is he did those three things all in the same night. Oh. All those crimes should have him in prison forever, if you ask me.
I don't know.
Mercy to the guilty is cruelty to the innocent.
I don't know the details, right? So I can't say, but you probably need to talk to somebody, either report to the police or you need to talk to an attorney on where you would actually have to file. To me, it's pointing to New Hampshire, but an attorney who
well, I'm sorry to bug your show with this because I don't have any ill will towards you, and yes, I'm not an anarchist, so that I guess that makes me a critic if I were to call in and support George Bush. I voted for him proudly in 2004, and yeah, I think he always gets stage fright. And that when Will Ferrell said that strategery word, when I was watching Saturday Night Live back in the days when I did, I about wet my pants.
Oh, yeah.
Beyond funny.
You've been a critic of the show, but you were not coming on the show today to criticize my work, and that's fine.
I'm not a critic of the show. I'm not against what you hold dear. I'm a critic of things you say and believe. That's nothing personal.
Oh, I know.
I'm not a critic of the show. You're an anarchist or voluntarist, whatever the hell you want to call yourself. I'm not a critic of that. I can understand your worldview entirely. I don't share it, but I respect it. So long as you respect my right to express my beliefs and don't slander and attack me for things that I don't believe would never say, never do, and would condemn anybody that does.
We're actually back
you're a
live.
call
We're back live. My name is Marc Stevens. This is the No State Project here on LRN.FM. And we're actually in the last two segments of the big show today. So if you want to join me, it's 218-632-9399, 218-632-9399. Skype is the Frank Rizzo 3. Frank Rizzo with the number 3. Oh, and if you do call in, the 2020 is the passcode. 2020 plus the pound sign. So I wanted to get back to this flipping of the burden of proof, though, and let's just assume that that's going to happen all the time, which is, it does happen. I just tend to get it more outside of court, and it is a real dishonest move because, look, everybody knows the burden of proof is on the prosecution. Just basic principles of logic, and I go through a lot of detail in the video, so definitely check that out at markstevens.net, and my YouTube channel, of course, is No State Project. But this is a really, really dishonest thing, and look. It's fairly easy to overcome that. The problem is that usually when the guy who is making this and doing this and flipping the burden of proof on you like that, they know it's a dishonest move. You're talking to somebody where typically rational discussion is over at that point. That's their way of saying they're done. Okay, it's not as explicit as if you don't like it, appeal it, but nonetheless, It's still their way of saying, I'm not a rational person, and I really don't want to engage you in this. That's all it is. But to have it happen, like Andy mentioned, Jay in Texas mentioned, to have that brought up in court by the judge, wow. I mean, do you need, at this point, more information and more evidence that the judge is prosecuting you? I wouldn't think so. Because the motion to dismiss, yes, and I will be doing some updates. I have updated the federal one, so I'll be adopting some of the changes there and making it shorter. But the purpose of the motion to dismiss is not to just say, hey, I disagree with this. What you're doing with the motion to dismiss is laying out why you disagree. You have your grounds. So your grounds are fully provided there. We mentioned that the only thing in the record or on the record is from the police officer. And the police officer is making an allegation. That's what he's doing. He's making certain statements of fact. Now, let's say he's saying that he saw James and Gilbert. He saw him on Gilbert Road and Baseline. That's a factual statement. Most of the rest of what he's saying is going to be a legal conclusion. And of course, we know the standard one. I saw James. He was physically in Gilbert, Arizona. That means the Constitution laws apply, and I have jurisdiction to investigate. Those are the only, so keep in mind that they're mainly legal conclusions or allegations on the ticket. So we're pointing out that the only thing they have, besides my physical location, are legal conclusions. They bear the burden. You don't make a prima facie case with allegations. Okay? Let's have that tattooed, just like every question in a cross-examination is... Every question should be a leading question. An allegation or allegations on their own do not make a prima facie case. A prima facie case, meaning at first glance, has to have evidence to back it up. Prima facie just means that they can tell you what the evidence is. It's not being subjected to cross-examination and challenge. It's just this evidence without challenge, not knowing the chain of custody, not knowing anything else. This evidence, when I first look at it, tells me you may be guilty. You do not reach that level with an allegation. Oh, how do you know that, Mark? How many times do we hear them say that to us? They will accuse us of conclusory statements. I'm going to do a video, this lying U.S. attorney, Jennifer Rubin. Yes, I'm going to do another video. She wasn't directly involved, but it involves her. In her own paperwork, citing the Supreme Court, conclusory statements are not enough. What's a conclusory statement? That's like saying you violated the law. A conclusory statement is you're physically in Arizona, the laws apply. Legal conclusions, conclusory statements are not sufficient to make a prima facie case. And if they haven't made a prima facie case against you, guess what? No burden, even the law of presumptions, doesn't shift. It's not presumably correct unless there's evidence. Mere allegations are not enough. This is basic common sense. Oh, why? Because, yes, basic principles of logic do apply in legal land. They just don't like that you are calling them out on their BS. And that's why they'll beat their chest saying, you got to use legal logic, not college logic, legal law. No, that's not true, because so much of legal principles and objections or not are based on basic principles of logic. And that being, the one who makes the allegation bears or makes the claim bears the burden of proof. That comes straight from the principles of logic. And in a criminal prosecution, the prosecution bears the burden of proof. And you can say, well, what about in a civil context? They still have a burden by showing it by preponderance of evidence. So if the plaintiff files against you and has no evidence, you don't have to put any evidence. It doesn't shift to a preponderance of evidence until the plaintiff has shown proof that there's jurisdiction, that they have a valid claim. They have to show subject matter and personam jurisdiction. And they can't do that usually. Well, almost no. Well, they can't. They can't show the laws apply to anybody. So they can't show jurisdiction. They can't show a legal injury. So this flipping of the burden, easy to address. It's just they ramp the stress up. It's just like Max was saying. It's a stress. Well, look, nobody wants to go to court. It's a stressful thing. You can go to jail. So, we understand that. And that's why they intimidate. They have to make these statements. They have to lie to you. They have to gaslight you into getting you to back off. You can't use logic here. So this is illogical? This is legalistic gibberish, to borrow the phrase? So we just object and ask questions. Objection: has the prosecution filed sufficient evidence to meet their prima facie burden? Simple question. Very difficult for them to answer. We go through this with the IRS. Even when you have evidence from the IRS themselves admitting to not having proof, they absolutely will not strip them of their presumption of correctness or their prima facie showing. We'll be back with the last segment in just a moment, so don't go away. Yes, welcome back to the No State Project. We're in the last segment here of Anarchy Radio for April 22nd, 2017. Glad to be with you here today. May get some video of the show, of actual video of the show. Maybe we'll do that, but either way, we'll still have it posted on YouTube soon. And also, Calvin will get the podcast on markstevens.net. But we're talking about dealing with the flipping of the burden of proof, which, this is why we have also the motion, the unsigned plea of guilty. Just if the prosecution has met their prima facie burden up to this point, I'll plead guilty. But to get what we were talking about before the break here on the big show, this is the prima facie case, or the presumption of correctness, is very an insidious part of the tax system, and look, it's like a lot of things here. There's one thing where the regulation or the code says one thing, and then you've got something else that happens in practice. And it used to be, when I first started doing this, they would cherry pick. Cherry picking means you just take what you want and anything that agrees with your position, and you just ignore the stuff that doesn't. So what they would do is they would say, well, we're the IRS, and when we make an assessment, there's a presumption it is correct. And you're like, damn, wow. And so once they make they have, they do the assessment and it's presumed correct, then the burden shifts to us, the accused, to then show that it's wrong. And you're like, damn, how the hell do you do that? That sucks. Well, of course, they're cherry picking. They're not giving you the entire quote, because as corrupt as the courts are, as horrible as they are, they do have some rulings, a lot of rulings, that sound good on paper. Because the IRS does not have a presumption of correctness unless the assessment is based on facts. See? That's why I'm going to do a video about this Evan Moses and this damn appellate panel up in San Francisco. The entire basis of the assessment from the IRS, the same as you're getting a traffic ticket or being charged with possession, all of those allegations rest on the same foundation. Dude, you're in Arizona. Our rules apply. You have to do X, Y, Z. You didn't do it. You can be charged. And they think that just saying that is they're presumptively correct. No, you have to have evidence. The presumption of correctness does not arise unless it's based on evidence. Helvering versus Taylor involved the Supreme Court and had to do with an IRS, or the Bureau of Internal Revenue, I think, at the time. Same agency. Adamson versus Commissioner of Internal Revenue is another one that upheld the same thing. They do not have a prima facie case or a presumption of correctness unless the assessment is based on facts. Otherwise, it is what the Supreme Court calls a naked assessment. So some may say, yeah, but it's not a naked assessment. They do have some evidence. They're saying you earned this money and you did not pay taxes on it. That is a sufficient evidence to give them a prima facie case. I say, no, you're assuming it applies in the first place. Because whether you earned the money or not and paid taxes on it is completely irrelevant unless you've first proven that the code applies. I know they're all howling that the law applies. I get it. But, like I covered in the last segment, you don't get a prima facie case or a presumption of correctness unless it's based on evidence. Mere allegations are not sufficient. So if the foundation of your case is missing and is nothing more than an allegation with no supporting evidence and couldn't be supported by evidence, you don't have a presumption. Technically, you don't have a presumption of correctness, and you haven't met your prima facie burden. That's why we have these cases where people are being told the prosecution doesn't have to prove that. That's an issue of law. They're actually accusing you of something and saying that unlike every other element of the crime, it doesn't have to be proven. Don't buy that for a second. That is just BS. And yes, they're going to say it, but remember, these are criminals. These are people who force people to pay them. So not really, a credible source. So we're going to see what we do. We're going to break the rule a little bit here. We're going to call a mate from down under. We'll get him on the line here. Don't make a liar out of me, mate. We're trying to get Matthew from... we have Matthew.
Here?
Yeah, there we go. Welcome to the show.
Just 1 second. Okay, now I've got you without the background audio. That's great.
All right. So let everyone know what you're calling about.
Okay, so there's a fellow called Stefan Lawrence who pops in onto the NSP chat every so often. A few weeks back, somebody mentioned on the show that he was after help contributions for putting a better video editing computer together for you.
Yeah.
And it had been a while since I heard anything about it, and it was actually a little bit difficult to track him down on the chat because he's not always there. So I'd like to just remind everybody and perhaps come back in next week and the week after to just refresh people's memory.
I appreciate that. Yeah, that would be great. The limitation is on the computer is that there's only 2 gigs worth of processing speed, and that is not nearly enough. You'd have to have a minimum of 3, but 4 is probably the recommended. I have 16 gigs of RAM, but that's not. It's all throttled by whatever the RAM can do. I can have 2 gigs, 200 gigs worth of RAM. If my processing speed is just, I may be incorrect, but as long as my processing speed is limited, that's what's going to throttle the speed of the computer.
Yeah, I think most people that do the kind of work that you do aim for, a fairly high-end computer. So I think it's pretty reasonable to try and get something a little better than what you're using.
Well, I appreciate that. Yeah, I wish that we could just plug in a 4 gig processor into the motherboard on this Mac, but from what I'm told, Macs, they're soldered in. And you can't.
Yeah. Just for those that might be interested, what Stephen has in mind is to put together a Hackintosh, which is a regular PC running the Macintosh OS, which apparently is quite a popular thing to do amongst some people. So you'll get a faster computer than what is typically available even from the Apple store, and Stephen should be able to put that together quite a bit cheaper than Apple sell their computers for.
I could put a computer together for less than what Apple sells these things for. Way too much. I'll say that. Way too much for just an operating system.
Yeah. And just to, if I can ask while we're on air, your preference is Macintosh OS and Macintosh video editing software, isn't it?
Well, I have the video editing software that's for the Mac. I don't have it for the PC, so that would certainly...
Oh, okay. So, but anyway, one of the nice little side benefits of a Hackintosh is that it's just that little bit easier to run a PC operating system if you want to.
Oh, okay. Well, listen, Matt, I appreciate the call. So just hold on. We're actually totally out of time for this broadcast.
No worries.
So just hold tight. My name is Marc Stevens. Listening to the No State Project here on LRN.FM. We will be live on Wednesday. I don't know the date. Maybe it's the 26th or 27th. But Wednesday, this coming Wednesday, we'll be live. So till then, salud.